Hey, welcome back. It's Monday. We are not in court this week in Ori. We'll start back March 3rd, and then we'll have another week March 10th. So during that time, we'll have 4 judges. We'll have a plea judge and a trial judge on March 3rd. We'll have a plea judge and a trial judge on March 10th, where we had 4 in 1 week. I guess the week before last. And that was a lot to handle, but this is more back to basics. Start off with a murder case. I had the number 2 case on that list, which ended up pleading last week, which was attempted murder out of city of Conway, where a young man started shooting at a police officer. He got 20 years on that. I think we updated you last Monday. So today, what I wanted to talk with you about is what happens once we close the file. Once Terrell Austin last week was guilty plea, Walter Wariax was one of the trials. Either way, whether we close it by trial or plea, that person goes off to prison. Tyrell Austin got 20 years. And he'll have to serve about 17 of those before he become eligible for parole. But whether it's by plea or trial, as soon as you get to jail, you will go, or to prison, you'll go to reception and evaluation, what we call R&E. That's in Columbia. It is kind of a purgatory. It is a prison, but it's where everybody goes until they are sent off because of the degree of their charge or because of their age. There's a lot of stuff that they consider. They try to keep them away from co-defendants, all of that stuff. That happens at R&E. They stay there just a minute and then they go to Lee or Lieber or any of these other prisons across the state. I think there's 8 total, several of them in Columbia. But they go there and then they serve their sentence. While they're there, they give them a lunch tray and a pencil and a piece of paper, and those guys start writing appeals. I mean, in fact, within 10 days of the conviction, whether it's by plea or by trial, defense attorney just basically writes up an appeal. It's standard. Hey, we don't know what to appeal right yet, but we're sure there's something. Let's send in there and protect their right for an appeal. And when the defense attorney don't do that, then that can be a problem because that's going to come back at post-conviction relief. So they put that the person will start either filing pro se appeals or get an attorney up there. And they will start off each time saying, the judge messed up. You shouldn't have allowed this hearsay in. You should have allowed that hearsay in. You should have blocked this testimony. You should not have blocked that. The judge is always screwing up, and the prosecutor. That appeal goes to the Court of Appeals. It's in Columbia. Judge Paula Thomas from Pawleys Island, she's one of our local judges. She's on the Court of Appeals. Blake Hewitt is from Conway. He's on the Court of Appeals. That's the Court of Appeals there. And they are looking at whether or not the judge or the prosecutor screwed up. A lot of times those guys will say, no, you got a fair trial. It wasn't a perfect trial, but you got a fair trial. And maybe they could have done this right better, maybe they could have done that, but we affirm the trial court's decision. We affirm the jury's decision. Then they will appeal that to the South Carolina Supreme Court. And the Supreme Court may hear that case, they may not. That's called a writ of certiorari. It's a Latin term which means they can reject or take those cases. A lot of times they will hear some of those cases and they'll say the Court of Appeals got it right. We affirm the trial court and the Court of Appeals. If the Court of Appeals did something wrong or the trial court did something wrong, they will reverse and remand and say you got to give them a new trial. But most of the time on pleas, all of that stuff goes fine. You don't ever have a problem with pleas, because as long the judge who's taken the plea probably takes some extra time by saying, hey, Ms. Smith, are you happy with your attorney? Did they help you in any way? Everything you ask them to do. Did they explain to you this? Did they explain to you that? And when the person would ever say no, he'd say, all right, well, let's take a break, go back and explain that and come back. It takes more time than probably we would want to move another plea, but that's why the judge is doing that, because everybody is going to appeal. Once they finish all of those appeals at the Supreme Court, everybody says the judge didn't screw up, the prosecutor didn't screw up. Then they start a series of appeals called post-conviction relief. And that's where the defendant is saying, all right, the judge didn't mess up, the prosecutor didn't mess up, my attorney messed up. Somebody's fault other than mine. If it weren't for his screw up, I wouldn't be in here. So that starts at the circuit court level. That starts at the trial court level. And a judge hears them say, why they believe their attorney screwed up. The Attorney General represents us, and a paid lawyer out of Columbia will represent the defendant. Most of the time, they say, well, again, the standard is you're not entitled to a perfect trial, you're entitled to a fair trial. And there's going to be mistakes in every case, whether it's a plea, whether it's a trial, somebody's going to stutter a word, da-da-da-da-da. It ain't got to be perfect. It's just got to be fair. So most of the time, that is upheld at the district court level. Now, we had a judge the other day that sent back 3 of them in 1 week. I don't know that I've ever seen that. So we've appealed all of those decisions, and we're appealing those. But most of the time, it's the defendant that will appeal to the Court of Appeals. They'll have to hear it. Then they'll appeal to the Supreme Court. So it's 5 or 6 appellate processes. We always get this question, how many, how long? It goes on for years. From the time the person goes to jail until they're released, 30, 40 years later, they're constantly appealing. When that rolls off, they will start with the federal system, and that's called habeas corpus. Well, it wasn't the judge, it wasn't the prosecutor, it wasn't my defense attorney. It is the system. The state system is rigged. We need the federal people to come in and fix it. And you notice it's always the defendant pointing fingers at someone else. It wasn't that I shot 2 people, it's that he messed up, he messed up, he messed up. So that's what all these appeals are for. Usually on a guilty plea, you're never say never, but on guilty pleas, because of all of the questions that's asked, those are usually upheld. For a trial, every time the defense attorney says, objection, Your Honor, that raises a red flag in the paperwork that the court reporter is taking down. And the Court of Appeals and the Supreme Court will go back over every one of those red flags and see whether or not it is a valid response. So that is the process. How long it takes, basically it's as long as he's up there until they carry out the death penalty, or he dies, or he is released from prison for maxing out his sentence. You're going to see an appeal over and over and over. So it lasts. Whether it ends up being successful is a different matter. But as long as there's paper, there will be appeals. And that's kind of what we learned. Once the defense attorney, the free defense attorney is over, they'll start doing them pro se. So it goes on forever. But fortunately, unless we really have an anomaly, most of them are upheld. So have a great week, and we'll come back and start March off with a bang.